I wanted to discuss in the 5th video at Fenster and Cohen Trial Lawyers the steps that you need to take for legal protections in each facility. Under Florida law, and in fact nationwide, the law is different as to each facility that may be negligent in the care and treatment of your loved one. For example, in independent living facilities in Florida, this is one of these facilities connected generally with assisted living and a nursing home, called Continuum of Care Facilities. There are no protections for a senior in an independent living facility. In terms of an assisted living facility and a skilled nursing home, there are protections called the Nursing Home and ALF Bill of Rights, and these are particular rights that each resident has in each facility to be protected. Now let's talk about the choice of facilities. In Florida, assisted living facilities are a huge business. In fact, up in Boca Raton, they're so large, they have over 1,000 residents in these facilities, and the facilities have their own bank branch. Some of them cost as much as $10,000 a month to have waterfront assisted living facilities, but don't get me wrong, an assisted living facility is limited on what they can provide. Generally, all their obligation under the law to do is to provide a safe environment and to monitor the condition of mom or dad. They do not provide care. In an assisted living facility, the most important thing that you have to notice is the ability for your loved one to perform activities of daily living. They can take care of themselves somewhat, but once they lose the ability to do activities of daily living, and they can no longer walk and are wheelchair bound 24/7, it's a good idea to move them out of the assisted living facilities. The assisted living facility has no duty to provide access or to provide medical and nursing care to a loved one. That's like a hotel. It's on the menu. In Florida, a skilled nursing facility is subject to the Nursing Home Bill of Rights under Chapter 400 of the Florida statutes, include the right to adequate and appropriate health care, the right to be treated with dignity. And this is under Chapter 400 of the Florida statutes. It provides an exclusive cause of action. And then the critical care hospital or the rehabilitation hospital are bound in Florida by Chapter 766, the medical malpractice statute. So we go all the way from common law negligence to bills of rights and ALFs and skilled nursing facilities and ultimately to the hospital. So different laws apply to each facility, but you have to be proactive. Toward the end of this video, I also want to tell you that if you determine that things happen, in my next video, I'll discuss the kinds of problems that can develop, particularly in ALFs and nursing homes in Florida. But if you discover a problem, it's not wrong to relocate your elderly relative. Move them. There's an old movie, a comic movie, that says move it, move it. If you're not satisfied with the care and treatment you're getting in a skilled nursing facility, feel free to move your loved one to another facility that's rated more highly. One of the more shocking facts that folks understand when I discuss it with them, take a look at the monthly bill of your skilled nursing facility. The average bill in Florida for a loved one to stay in a skilled nursing facility runs between $10,000 and $14,000 a month. And for that kind of money, you should get terrific care. But in Florida, it's sad. So in my next video here at Fenster and Cohen Trial Lawyers, I'm going to tell you the issues and the rights that seniors have, and if you choose, the next video is how to choose an attorney, and then what should the attorney do.